Contracts are vital in today's society. The principal reason for enforcing agreements is economic necessity. Agreements are essential to trade and commerce arrangement, and if they are not enforceable, trade as we know it would be virtually impossible. It would be virtually impossible because there would be no certainty with the trades and commerce arrangements we make. There are many contracts associated with day-to-day activities. Some examples of entering a contract would be catching a bus, buying lunch, or buying a newspaper. These examples involve contracts which are formed by two parties. However, contracts aren't always valid. They could be misleading and result in economic loss and other personal loss. If a contract is misleading or fraudulent, defenses are able to recover personal and financial loss. A case that will be analyzed is the case of Brown versus Miller. This case is important as it outlines the unfair treatment and possible undue influence towards the defendant, Mrs. Brown. To be successful in a case where there is a dispute between the parties to a contract, basic knowledge about the contract law needs to be obtained. Firstly, a contract is an agreement which the courts will enforce. A valid contract is an agreement made by two or more parties that create legal rights and obligations which the law will enforce. Three essential elements need to be present so that a binding or valid contract can be created. The first element is intention to create legal relations. This element means that the parties who have an agreement supported by the consideration may not necessarily be legally bound by their agreement. To be bound, the parties must also intend their agreement to be legally binding. In domestic and social agreements, parties do not intend their agreement to be legally binding, whereas in business and commercial agreements, the parties would intend the agreement to be legally binding. The second element is offer and acceptance. Firstly, an offer has to be defined as a clear statement of terms by which the person making the offer is prepared to be bound. An offer is a proposal by one party to enter into a legally binding contract with another. An offer can be made orally, by contact, or in writing. An offer must always be clear and certain. The second part of the second element is acceptance. Firstly, acceptance occurs when the party to whom an offer is made, offeree, agrees to the proposal of the person making the offer, offerer. An important difference between the concept of an offer and acceptance is that when we refer to the communication on an offer, we mean that an offer must actually be communicated. In relation to acceptance, there are seven general principles. These are shown as following. An example of one of these principles is that acceptance can only be made by the parties to whom the offer was made. This means that anyone other than the party to whom the agreement was made to cannot be accepted. The third and last element of a contract is consideration. Defining consideration precisely has been the subject of judicial discussion for many years. For an agreement to be binding, some gain or benefit must pass to the person making the promise. All contracts must have consideration present to be enforceable. In relation to consideration, there are 10 general principles. These are shown as the following. An example of one of these principles is that consideration must be definite. That means that consideration must be specific and exact. A contract can be set aside on a number of well-established grounds, even after a contract has been validly entered into. The effect of being able to set aside a contract is that it may be found to be void or voidable. These two terms, void and voidable, are extremely important to know what they mean. Firstly, void means that the contract never existed in the first place. Secondly, voidable means that the injured party can decide if the contract is to continue. There are three general terms which are lack of legal capacity, lack of genuine consent, and legality of object. With lack of legal capacity, the court requires parties to an agreement to have the power/ability to enter into that agreement. Lack of capacity includes bankruptcy, criminals, mentally impaired, etc. Lack of genuine consent can be affected by the mistake of which it came into being. If the contract is illegal, the contract is void and of no legal effect. There are vast amounts of remedies available for a breach of contract. A person can either continue on with the contract or rescind if the nature of the breach of contract gives one party the right to end the contract. If the nature of the breach does not entitle one party to the contract to end the contract, the innocent party may, in certain cases, sue for specific informants, in certain cases sue for an injunction or sue for damages.
Created using Powtoon.